Okay, I think we'll kick off. We're a few minutes after and we could have one or two latecomers. But welcome everybody to webinar 3 for 2023. And for those who don't know me, I'm Donna Mogg, the Fair Farms Grower Engagement Officer. And today we're going to be talking about labour hire providers. We're all very familiar with that topic, and anybody who's been a member of horticulture and particularly of GrowCom in the past 10 years will understand why this is so important. But the other thing I want to talk about is now there's potential for a national scheme. Now, it's been on the agenda since year dot. I know that we were talking about it when we were having discussions around the Queensland scheme, that a national scheme would be a much more efficient and effective, potentially effective anyway, form of scheme for horticulture, because so many of our labour hire providers operate across state lines. So we finally got to the stage now where the government has set out some key principles for what that national legislation might look like. So I just want to cover a bit of that today. We're down for half an hour, so I don't think we'll take too much longer than that. But if we do, feel free at any time to give me a call, and I'm happy to discuss this with you. So today, just a little labour hire provider refresher. So effectively what's in place now, as I said, a bit of a discussion around a national labour hire providers licensing scheme, and just a few reminders for us when we're working with labour hire providers. Pardon me, I'm a little croaky this morning, so excuse me if I croak out. Okay, so let's start at the beginning. So a labour hire provider is a business that has an arrangement in place with one or more individuals, so their workers, to supply those workers to perform work in and as part of a host business. And they are obliged to pay, pardon me, the individual for the work performed for the host. So we all have a fairly good understanding. Those of us who use labour hire providers know how this works. A labour hire worker is someone who enters into a work contract with a labour hire agency or a labour hire provider, and that labour hire provider has a commercial contract to supply labour to a host firm, and the worker performs work for the host firm. So the host firm pays the labour hire agency, the LHP, and the LHP then pays the workers. The worker has no contract with the host firm and as a result cannot make any unfair dismissal claim against the host firm. If they were to be terminated, they would be terminated by the labour hire provider, and any action that an employee wished to take would be taken against that employer. But of course, we know that we have obligations towards workers that we recruit through labour hire agencies. So this is a fairly good, just a visual. It's a very simple one. So labour hire agency, work contract with their worker, labour hire agency, commercial contract with a host firm, and the host firm, because those workers are on the farm of the host firm, the host business is responsible for the performance of that work. Now, we should have a little disclaimer here, because labour hire providers are a key and important feature and legitimate players in the horticulture industry. They have been around since year dot, and they have always been a feature of our industry. As employers, labour hire providers have exactly the same obligations under Australian laws as any other business. So we don't expect them to do anything above and beyond, but we do expect them to comply with all of the relevant laws. But they deliver an important service to business, in the words of the NFF, supporting the supply and mobility of workers and creating administrative efficiencies for business requiring workers. However, while many labour hire providers do the right thing and operate lawfully within the law, many reports have shown that some labour hire providers have and are continuing to breach their obligations and are denying workers their lawful entitlements. So if we go back to all of our discussions around managing risks with labour hire providers, we remember this key term, accessorial liability. And what that means is that when a person or a company, so a host firm, is involved in the contravention of a workplace law that is undertaken by a labour hire provider. So, for example, if your labour hire provider is not providing superannuation or is not providing proper wages, if you haven't done your due diligence around this, then you could go for accessorial liability for that breach by the labour hire provider. So when this happens, the host employer is treated the same way as the actual employer, the labour hire provider, who is responsible for that contravention. They can be ordered by a court to pay employees unpaid wages and entitlements, and they can be levied penalties for their involvement in any contravention. And a lack of knowledge about this is no longer a defence. Ignorance is not a defence. It is your obligation as a host employer to do your due diligence and make sure that those labour hire providers that you're working with are doing the right thing. If not, then you're likely to come up against this. We certainly are aware of a number of growers who had to pay the payroll twice because the labour hire provider, unregulated, in an unregulated state, took off with the payroll. So those workers needed to be paid and the grower was liable to pay those wages a second time. So you can see how important it is to work closely with your labour hire providers. So when we talk about a contravention, it means that the business or the company, so the person or the company, that is the host employer, has assisted, recommended or caused the contravention, has influenced the contravention by making promises or threats, was knowingly concerned in or was a party to the contravention so that they had some knowledge perhaps of what was going on or even some suspicions but didn't bother to check, or they conspired with others, which resulted in the contravention. So if anybody can find any grounds under those contraventions, then accessorial liability will come into play. And a person or a company, and this is really, really important, can include directors of companies, HR managers or other managers. So if a HR manager is responsible for overseeing discussions, negotiations and agreements with their labour hire provider, and they have let something slip through, they may be personally liable, as well as a payroll officer, your accountant, or any other business involved in the company's supply chain. So the accessorial liability provisions allow the Fair Work Ombudsman effectively to hold anyone responsible for a contravention, even if the business has gone into liquidation. So even if a labour hire business has gone into liquidation or the host business, that will not stop the Fair Work Ombudsman from following up and seeking to rectify those problems. So this one's really important because it does mean that people like HR managers, work health and safety managers, payroll officers and your accountants can all be held personally liable for a breach that occurs in your workplace. And that breach may not have been done by you or them. It was probably done by the labour hire provider. Nonetheless, accessorial liability means that you could be liable and accountable for those issues. So it's all about supply chain management. And if you can recall our earlier webinar around social compliance, we talked about how those issues around social compliance, around modern slavery, around discrimination, around proper treatment of workers are being pushed down further and further down the supply chain, courtesy of the Anti-Slavery, the Modern Slavery Act. Which requires those buyers of yours, the retailers, to provide comprehensive reporting to the government about how they manage modern slavery risks within their supply chains. So if you recall that discussion, if not, we have that webinar available. You can always go back and have another look at it. But essentially, that means that labour hire providers are part of your supply chain. So there's the expectation of your customers, the retailers, that you can and will demonstrate how you identify, assess and manage your supply chain risks. So this covers a couple of areas of the Fair Work program, including labour hire providers, managing those providers, and then also looking at managing the rest of your supply chain risks right through to your retailers. The Fair Work expectations, and this little cutting comes actually off the Fair Work website, effectively is that you will know the pay and conditions that apply, that you will ask your labour hire provider about their workplace practices, that you will check the contract price to make sure that the labour hire provider is paying properly. You will set clear expectations with the labour hire provider, so what it is that you expect of them as part of your supply chain. And you need to know about subcontracting. That's another really important element for growers to be aware of. I'll do a little bit more on this a little bit later. Let's have a look at the current situation of labour hire legislation in Australia. So Queensland, Victoria, South Australia and the ACT all have labour hire licensing regulation. Queensland was the first cab off the rank in 2017 with South Australia and Victoria following close behind, and the ACT has recently come into the game with their own act. New South Wales, WA and the Northern Territory currently has no state-based labour regulation or labour hire regulation. So it can be a bit of cowboy country up there. Labour hire laws, they're similar but different. So the same elements apply in terms of all operators must be licensed. All users of labour hire providers must only use licensed operators. Don't forget that. You must only use a licensed operator in those states. And all of the laws have penalty structures, but they approach them quite differently. The key differences are, well, Queensland, Victoria, ACT all cover the entire labour hire industry. South Australia covers only part of the labour hire providers of the labour hire provider industry, but that does include horticulture. And neither Victoria nor ACT appear to require any kind of financial viability test. This is information off the websites, so that does not appear to be a feature, although I find that rather unusual. I'm sure that it comes in somewhere. Each of these laws have, except the ACT, have the fit and proper person test. So that means that a labour hire provider must meet those standards in terms of a fit and proper person test in order to apply for a licence, and those are set out fairly comprehensively on each of the websites. Queensland and Victoria have funded enforcement activities, but Queensland has really been the one that has taken enforcement to an expected level. There's no point having this legislation that contains commitments to enforcement and commitments to penalties unless there is actually a statutory body, an enforcement body, to actually implement those enforcement activities. So Queensland has a fairly strong record of enforcing the labour hire legislation in Queensland, and I suggest if you ever get a chance, go onto the website and have a look at the website, and you'll see the results in their annual reporting about their enforcement activities. All of them are overseen by different state agencies and have different appeal mechanisms and decision makers. Queensland and ACT have licensing for 1 year that is renewable every year, but Victoria actually licenses for 3 years, although there is an annual licence fee. And South Australian licences appear to be unlimited, and again, there is an annual licence fee. So as you can see, while there are similarities in it, the legislation, the pieces of legislation themselves are quite different. So the idea that we're going to somehow either pull these all together or extract the most important bits out of them to write a national legislation for labour hire providers is not perhaps as easy as it might sound. These are just the websites. I thought it would be useful to have a look at those. So the Queensland Government up in the top left-hand corner, WorkSafe ACT. So what we see in Queensland is labour hire licensing has its own authority. In the ACT, it operates under WorkSafe. And in Victoria and South Australia, they also have their own licensing statutory authorities. Okay, so when I have a look at the potential, and this has just kind of come to bear in the last week or two, when we saw the announcement by Minister Watt and Minister Burke, respectively, about the potential for a national labour hire licensing scheme. So there were a series of workplace reform consultations earlier in the year, where they've set out some key objectives for any national labour hire regulation. And those are that it should provide a level playing field for business to promote accountability and transparency, to protect labour hire workers from exploitation by providers and across their supply chain. So this is where we come in again. To promote greater compliance with relevant laws and to drive behavioural change, and to reduce red tape and confusion for labour hire providers operating across multiple jurisdictions. The horticulture industry, via the NFF Horticulture Committee, government and the unions have agreed now on 5 key principles by which any national scheme should be considered. So there have been discussions with our industry and with unions, as is important these days. And they have come up with these 5 principles towards a national approach to a labour hire licensing scheme. So principle 1, again, they're reflective of the DUA consultations, but have a little bit more detail. So again, should be inclusive of all industries and not limited to high-risk sectors only. So remember I said that some of the existing schemes, in fact, are limited to, a range of what they consider to be high-risk sectors in the labour hire industry. We're saying that it needs to be inclusive of every industry. If you're going to do a national approach, then it should apply to everybody. Principle 2, it needs to allow for businesses to operate across state and territory borders with clarity and simplicity. So we know that some businesses register themselves in every state that has a licensing scheme. But it's also obvious that what we have is a number of labour hire providers operating within and outside of their own state borders. So in regions where there is licensing and also in regions where there is not. I'm happy to report that most of the comments that I get back from growers in unlicensed states, so WA in particular, South Australia and NT, is that they're still seeking licensed labour hire providers where they can. So, the Northern Territory might, for example, utilise Queensland labour hire providers because they are licensed. But obviously that's not happening in all cases, and we're still getting stories about exploitation and abuse of workers. Principle 3, any national labour hire licensing scheme needs to be appropriately resourced and responsive. And that comes down to that earlier question of enforcement. So they need not only to have the legislation, but you cannot just pop it on a shelf and expect that everybody will follow through. There needs to be some enforcement of this, like there is in every other government-funded program. If you just think about the Fair Work Ombudsman, who goes out and enforces the Fair Work Commission's legislation and the awards, etc. Similarly, we need to have an enforcement agency that makes sure that these guys do the right thing. Principle 4, they can only be as effective as the compliance and enforcement action which underpins it. So we've already had a discussion about that. And they should sit on the foundations of a clear definition of labour hire. It should not start pulling in people around things like secondments. If you're seconding an employee to another business for a short period of time, recruitment agencies and the like. They need to be well defined so that people understand exactly who they're operating with and what the laws are approaching those companies. So what might a national scheme look like? Well, as we said, there are currently 4 schemes in place, all similar, but also all different. Now, I have to say, at this point, this is pure speculation. There is no solid scheme. This will require a lot more further work to develop a scheme that is appropriate. But if we look at what exists now, there seems to me that there's a couple of options. You could utilise one of the schemes and convert it to a national scheme, for example, the Queensland or Victorian scheme. Being a bit parochial in this space, I think that the Queensland scheme, with its strong enforcement model, may well be the best one if they were to emulate one particular scheme. That rarely happens. You could use a hybrid of the current schemes, so take out the best and leave out the worst of the existing schemes. You could create an entirely new scheme from scratch, but that seems to me, beg your pardon, that seems to me to be a bit of a pointless exercise. Why would we reinvent the wheel? Or we could keep the existing schemes, have them expanded or other schemes introduced into the states, and then have harmonised oversight. I don't think this is the way they're going to go. It's a bit like WorkSafe. where the work health and safety legislation is actually harmonised in a national piece of legislation, but enforcement of work health and safety is actually state-based. So that would be another option. Which option they might go with, I simply cannot say. As I said, it's speculation, but again, watch this space, because we're all over this like a rash, to make sure that we can keep you up to date with what might be coming. Okay, so just some gentle reminders about when you're working with labour hire providers. So bear in mind, you know that you need to do your due diligence. And the definition is the investigation or exercise of care that a reasonable person or business is expected to take before making a decision or entering into agreement or contract. It is a legal obligation to assess business bona fides and the potential risk, especially when it comes to labour hire providers. If you have not undertaken proper due diligence, then you may well find yourself liable and accountable under the accessorial liability provisions. You really need to have a written contract between the host employer and the labour hire provider. There is really no excuse anymore not to have a written form of contract. It's vital to establish the terms of trade, all of the relevant obligations, and on-farm processes and employee management. So that's where we write them to say the LHP will provide us with evidence of their workers' compensation scheme. They will provide us with evidence, pay slips and wage records, so that we can check that people are being paid properly. They will provide us with verification that these people are indeed legitimately entitled to work in horticulture or in Australia. So those kinds of things are written into a contract that oblige both the labour hire provider and the host employer to follow, to ensure that that the workers are treated legally and properly. And the other obligation the host employer has is to monitor workers. It's really, really important. You have to monitor the workers to ensure that what the labour hire provider is telling you and what is in your agreement is actually happening. We've certainly heard of stories where they're being issued with pay slips, or the host employer was issued with pay slips which showed one thing, but workers testified to a different thing. So it's really important that you do that. Again, a failure to monitor those workers to ensure that everything is in order may well lead you down the path of accessorial liability. So those are the three key elements when we talk about the management of our labour hire providers. So when we talk about due diligence, we talk about knowledge of the requirements under the laws. So need to understand, the terms of your award, the NES, and any other relevant laws that apply to your workers. You need to have an understanding of that term, accessorial liability, and what that may mean for you should the proverbial hit the fan. Applying due diligence processes and reference checks before you hire a labour hire provider to confirm the existence of the business, and that might be an ABN check. Who is the person who is listed on the ABN register as the director of the company, and if you're not dealing with that person, why not? Look at their history, look at their operational integrity, obviously look at whether they're licensed or not, whether they are Staff Sure certified or not. Staff Sure is the certifying body for labour hire providers Australia-wide, and certainly if they're not working in a licensing regime, they should be operating under the Staff Sure certification. So we highly recommend, and we do this in Fair Farms, say that you really need to, where you can, work with those labour hire providers, and ensuring wages and conditions, etc., are in line with awards. Where laws exist, again, only use the licensed labour hire providers. Where no laws exist, seek out your Staff Sure certified, now approved LHPs. And where there are neither, be extra vigilant. Try saying this with a mouthful. Be extra vigilant with due diligence. And that means to take some extra steps talk to people who may have worked with the labour hire provider in the past, ask them the hard questions, send them that agreement, and certainly we can help you out with those agreements. There is nothing in the template agreement in the Fair Farms manual that requires a labour hire provider to do anything other than what they're legally provided to do. So there is no reason why your labour hire provider would not sign off on this type of agreement. As we said, a written legal agreement for the provision of workers, which clearly outlines the parties' responsibilities and the obligations. And be mindful, particularly if you're using piecework agreements, they are individual agreements, so you need to have one with every single worker, including the, piecework arrangements they are now. And also be very mindful of subcontracting. So you need to have that conversation right up front, that if there is any subcontracting to be done, it is only to be done with your approval as the host employer. Excuse me. And have ongoing procedures in place, as we discussed, to check the workers' rights entitlements and that work health and safety is managed by both parties. Examples of procedures might include the labour hire provider providing you with regular wage records and pay slips, interviewing workers yourself about their wages and conditions, educating workers about their rights via training, via your own induction, which I would heavily recommend. You need to do a joint work health and safety induction on farm with your labour hire provider. Those employees may not be familiar with your farm or the processes or practices on your farm. So really important that you have that checked off and signed off by the employees. And also providing workers with a grievance process so that if there is any concern of workers, whether that's with you as the host employer or with their labour hire provider, they may not be game, or they may be afraid or too intimidated to talk to their employer, i.e. the labour hire provider. So they may wish to talk to you. If you hear something that alarms you in terms of the treatment or the payment, you really need to take action. You need to, go to the labour hire provider and try and sort this out. If it's found that you have ignored an issue and that issue is then taken to the Fair Work Commission, you will be drawn into that case. So it's really important that once you are aware of something perhaps going wrong, that you actually take action to try and manage it. So those are just some gentle reminders about existing labour hire provisions. Don't forget, Fair Farms is coming to an event near you very soon. And we're always happy to meet with growers, talk with growers, run little workshops for growers, little webinars, whatever it is that you want. We want to tell you about Fair Farms. So we'll be at the Banana Congress in Cairns, we'll be at the Northern Australia Food Futures in Darwin, we'll be at Hawke Connections in Adelaide, we'll be at the Tasmanian Fruit Growers Conference in Launceston, and we'll be at the Protected Cropping Australia Conference in Brisbane. And of course, Fair Farms has its own national conference coming up for its second year, and that will be in Melbourne in October. So keep an eye out for that. Oops, sorry. Okay, that's our today's webinar on Fair Farms. If there are any questions, we have kind of run out of time. I can't see the screen, so Josh, if there are any questions?
The chat looks clear from my end, Donna.
Okay. All right. Thank you again, everybody.
One moment, Donna. Sorry, we have got one from a while ago. Chris asked, will the national labour hire licence require that the labour hire company is certified to Staffsure?
I don't know the answer to that, to be honest with you. I just don't know the answer to that. It's all at the very beginning stages now. They've set out the principles, and now they have to decide which way they're going to go about developing this national scheme. So whether they take, as I said, an existing scheme and model that, or whether they start from scratch, or what they're going to do, we're not sure. So we're not really clear about whether they will require Staffsure certification. If there was a particular feeling about it, we'd be happy to take feedback on it. But again, watch this space. Okay, hope that answers your questions, Chris. Thank you so much, everybody, for joining us again this month. Really great to have you on board. As always, my details are here. This recording will be available for those who couldn't make it. And look, have a great week. We'll talk soon, I hope. Cheers for now.